Fraud is a constant threat to your notary commission. You need a shield. The book by Derek Spruill, Notary Fraud Shield, could provide you with some advice. Learn real-world tactics, notice red flags, and develop refusal strategies to protect your notary commission. Buy your copy of Notary Fraud Shield by Derek Spruill from any online bookstore, Amazon.com, Barnes & Noble Bookstore, booksofmillion.com, bookshop.org, Mobile Notary by DerekSpruill.com, or download from Kindle to obtain your essential notary book to help with all your notarization starting today.
Imagine for a moment that you were walking into this really bustling, brightly lit hospital room.
Right. It's a stressful environment.
Extremely.
Oh.
Like the steady beep of a heart monitor just echoing in the background. And sitting in the bed is an elderly woman, clearly exhausted, looking really small amidst all those pillows.
Yeah, we've all seen that.
And surrounding her bed is this entire group of family members. The energy in the room is just tense. It's impatient.
Oh, absolutely.
And one of them, maybe it's a son or a nephew, turns to you, thrusts this thick stack of legal documents into your hands, points to a blank line at the bottom, and just says, "Hey, we're in a massive hurry here. Just stamp it so we can get this over with."
I mean, it is a scenario that plays out across the country every single day.
Yeah.
And in that highly pressurized, really emotionally charged moment, you realize something profound. Your ink stamp is not just, an office supply.
Right, it's not a toy.
Exactly. It's not a rubber novelty. That stamp is the barrier between a person's free will and their total exploitation. You are the gatekeeper.
Wow. Welcome to Notary Knowledge. I'm Eddie.
And I'm Marylyn.
When you first step into this profession as a novice, there is a very specific, undeniable feeling that just washes over you.
Oh, for sure.
It's this potent mixture of profound civic responsibility and, if we were being completely honest with ourselves here, a little bit of sheer terror.
A lot of terror, honestly.
Right. You look at these massive stacks of legal documents, warranty deeds, complex affidavits, durable powers of attorney, and they can absolutely look like they are written in some ancient foreign language.
They really do. And I want to validate that feeling for anyone listening who might be new to the field.
Yeah, it's totally normal.
It is entirely normal. That sense of caution, it actually makes you a remarkably better official.
That's a good point.
Because the anxiety you might be feeling as an entry-level notary isn't a sign that you aren't cut out for this. Quite the opposite, really.
It means you care.
Exactly. It is a clear sign that you genuinely understand the gravity of the role. You are a public servant appointed by your state government to serve as a completely impartial witness.
The ultimate frontline deterrent against fraud in the United States.
Yes. But to be that shield, to protect that vulnerable patient in the hospital bed we just talked about, you have to know exactly what you are looking at.
Right.
Which is why taking the time to slowly and methodically learn the foundations is just so incredibly critical.
And that is exactly why we're here with you today. We really want to help you translate that intimidating foreign language of legal documentation into clear, actionable steps.
Safe steps, too.
Yes, very safe. Before we jump into the mechanics of today's lesson, though, I do want to encourage you to really invest in your ongoing education.
It's so important.
It is. This is not a profession where you just read a pamphlet once and you're good for life.
Definitely not.
A fantastic starting point, an absolute must-have for your desk, is purchasing the Notary Knowledge books by Derek Spruill.
They are amazing.
They really are. An indispensable, comprehensive resource for navigating those weird gray areas of the job. And you should also make it a daily habit to visit the Notary Knowledge website for crucial legislative updates and operational tools.
And, if you happen to be a visual learner, or if you're just looking for robust refreshers throughout your busy week, you definitely need to check out our video podcast, No Notary, with Eddie Montes Travis.
Well, that one is great.
It gives you these incredibly deep operational masterclasses that you can actually see in action.
Yeah, seeing it done makes a huge difference.
It does. Also, you absolutely must tune in to Marylyn's 90 Seconds of Notary for those incredibly fast daily compliance tips.
Perfect for the morning commute.
Exactly. You can easily digest them while you're having your morning coffee before you hit the road for your appointments.
Those daily tips have saved countless commissions, I can promise you that. Now, if you have been following along with our prior shows, you know we have been building your fundamental toolkit piece by piece.
Week by week.
Yeah. Like, we recently spent an entire show talking about the absolute non-negotiable necessity of keeping your stamp locked up and completely secure.
Treating it like a loaded weapon of legal authority.
Yes, because in the wrong hands, I mean, it can literally be used to steal someone's home. We also spent considerable time navigating the difference between the venue and the county of residence.
Which trips up so many people.
It really does. Just as a quick reminder, the venue is simply the geographic location where your feet are physically planted during a signing ceremony.
Right, versus your county of residence, which is merely where your commission lives on paper in the state's filing cabinet.
Exactly. So building on all of those vital lessons, today is a very special installment of our curriculum.
It is. Today is Foundational Fridays, decoding the document certificate types.
The mission for today is simple to state, but it's massive in its scope. We are going to master the essential notarial acts.
We really are.
We're going to completely decode exactly what these different certificates mean. And most importantly, we're going to learn how to expertly handle those tricky, highly pressurized, real-world scenarios.
Like that hospital room.
Exactly like the hospital room, where you feel pressured by a client, but you need to act without ever crossing the strict legal lines that protect your commission and your livelihood.
Which brings us to the most critical, overarching distinction in our entire profession.
Okay, let's get into it.
If you truly understand this one foundational concept, literally everything else we discuss today will naturally start to fall into place.
No pressure, right?
Right. We have to look at the conceptual foundation of the two most common notarial acts you will ever perform: acknowledgments and jurats.
Okay, acknowledgments and jurats.
But before we define the acts themselves, we actually have to take a step back and define you.
Define the notary.
Precisely. We have to define the fundamental nature of the notary, the actual role we play in the legal ecosystem.
Okay, so what exactly are we?
As a notary public, you are what the legal system calls a ministerial official.
Ministerial. That sounds very formal.
It does, but that word, ministerial, is vital to internalize. And it has absolutely nothing to do with religion.
Right, it's not about being a minister at a church.
Exactly. In the context of government and law, a minister is a servant to a process.
A servant to a process. I like that.
Being a ministerial official means you are a public officer who follows strict, pre-written statutory rules. You do not have to, and you actually aren't legally allowed to use significant legal judgment, analysis, or discretion.
So we aren't analyzing the documents themselves.
No, not at all. You do not assess the inherent fairness of a business contract. You don't determine if a complex real estate deal is like a sound financial move for the buyer.
That's the lawyer's job.
Right. Your job is entirely procedural. You verify the identity of the human being in front of you, you assess their basic willingness to proceed, and you administer the proper statutory act.
Got it.
You are the guardian of the procedure, not the author or the judge of the document.
The guardian of the procedure. So we aren't the judge looking at the evidence. We are the bailiff ensuring the rules of the courtroom are followed.
That is a brilliant way to put it.
I think that framing relieves a lot of pressure for novices who feel like they need to understand every single clause of a 30-page commercial lease.
It definitely should relieve that pressure.
So let's look at the first major tool in our procedural toolkit, the acknowledgment. Whenever I'm training someone new, I like to casually call this the free will act.
That is a highly accurate shorthand, actually. The primary purpose of an acknowledgment is essentially twofold.
Okay, what's the first part?
First, you are positively identifying the signer according to the strict laws of your specific state.
Which usually means looking at an ID, right?
Exactly. Relying on an unexpired, government-issued photo identification card, like a driver's license or a passport.
And the second part?
Second, and crucially, you are confirming that the person signed the document voluntarily.
Hence the free will part.
Right. Entirely of their own free will, without any visible signs of duress or coercion.
And here's a mechanical procedural detail that trips up like a massive amount of entry-level notaries.
Oh, I know exactly what you're going to say.
For an acknowledgement, the signer must personally appear before you physically at the exact time of the notarization.
Yes.
However, they do not have to actually sign the document in front of you.
That is such a critical procedural distinction.
People get so confused by that.
They really do. They could have signed that real estate deed a week ago while sitting at their kitchen table drinking tea.
Right.
But when they finally stand in front of you today, you are looking at their ID, looking at their face, and asking a very specific question.
What's the question?
You're asking, Did you sign this document, and did you do so willingly?
Okay.
When they answer affirmatively, they are formally acknowledging their previous signature to you, the impartial state official.
You are acknowledging the act that already happened.
Exactly. You will see acknowledgments most commonly attached to things like real estate contracts, property deeds, and powers of attorney.
Yeah, whenever I try to explain the boundaries of this act to someone who is brand new to the field, I use this analogy that seems to really make it click.
Oh, let's hear it.
I tell them to think of themselves as an elite art authenticator.
Okay, I like where this is going.
Right. When an art authenticator is hired to look at a recently discovered painting, their job is not to tell you if the painting is a beautiful masterpiece.
No, it's not.
They aren't even telling you if the subject of the painting, say, a landscape, is a factually accurate depiction of reality.
Right.
All that authenticator is doing is using their tools to verify that the signature at the bottom of the canvas truly belongs to the famous artist.
Yes.
And that the artist created it willingly rather than, being forced to paint it at gunpoint.
That is exactly what an acknowledgement is.
You aren't saying the financial contents of the durable power of attorney are a brilliant idea. You are merely authenticating the physical signature and the free will of the person who put it there.
I love that analogy because it perfectly captures the limits of the ministerial nature.
Yeah, it keeps it simple.
You authenticate the origin, not the content. Now, we have to contrast that free will act with the second most common and arguably much more serious act in our toolkit.
The Jurat.
Yes, the Jurat. If the acknowledgement is the free will act, the Jurat is fundamentally the absolute truth act.
The absolute truth act. That carries a much heavier, almost intimidating weight to it.
It does, and legally speaking, it really should. The primary driving purpose of a jurat, which in some state statutes is also formally referred to as a verification upon oath or affirmation, is that the signer is actively swearing a legal oath.
Like in a courtroom.
Exactly like in a courtroom. They are swearing under the severe legal penalty of perjury that the contents of the document they are signing are entirely factually true.
Wow. So the physical mechanics of performing this act must be radically different than the acknowledgement.
They are completely different, and mixing them up is a fatal flaw for a document.
Okay, break down the mechanics for a jurat.
For a jurat, just like the acknowledgement, the signer must personally appear before you. But unlike the acknowledgement, they absolutely must sign the document in your direct physical presence.
Oh, so they can't bring it in already signed.
No, they cannot bring you a previously signed document and simply acknowledge it for a jurat.
What happens if they do? Like, what if they bring you an affidavit they signed at home yesterday?
You have to force them to cross out that signature, initial the cross out, and sign the document again fresh, right in front of your eyes.
Okay, that's a huge difference.
And then comes the most critical, legally binding step. You, the notary, must administer a formal verbal oath or affirmation.
You actually have to say the words out loud.
Yes. You must ask them to raise their right hand, or place their hand on a religious text if they prefer, and verbally swear or affirm that the statements contained within the document are true to the best of their knowledge.
You see, jurats used constantly on things like legal affidavits, court pleadings, or sworn depositions, right?
Yes, all the time. These are documents where a judge, a court of law, or a receiving government agency desperately needs to know that the person is willing to face real criminal consequences.
Like fines or even jail time for perjury.
Exactly. If they are found to be lying on the form, the oath is the mechanism that triggers the perjury liability.
Okay, so we have the Free Will Act and the Absolute Truth Act.
Right. And there is a vital common thread that heavily connects both the acknowledgement and the jurat. We informally call it the golden rule of our entire profession.
The physical presence mandate.
Yes. The signer must always, without exception, be physically present.
So no phone call.
You cannot do a traditional paper notarization over a quick phone call or a casual Skype session or a FaceTime call just because you've known the person for 20 years and recognize their voice.
It has to be face-to-face.
Face-to-face. Now, to be highly precise, when we talk about this requirement for direct communication and physical presence, some specific states have established complex nuances regarding language barriers.
Oh, that makes sense. Because if you have to administer a complex verbal oath for a jurat, or if you have to carefully ask someone if they sign willingly for an acknowledgement, you obviously have to be able to communicate effectively with them.
Exactly. If you are speaking English and they only speak Mandarin, you cannot verify their free will or their understanding of the oath.
That's a huge logistical problem.
It is. Direct shared communication is the general absolute gold standard across the country. You generally have to be able to speak the exact same language to ensure they truly understand the gravity of what they are doing.
But there are exceptions.
Yes. States like Arizona, Colorado, and Mississippi have recognized the reality of their diverse populations. They do legally allow for the use of a physically present, completely disinterested interpreter during the verbal notary ceremony.
Wait, disinterested. Let me guess. That word is doing a massive amount of heavy lifting in that law.
Massive. The interpreter cannot be a family member, they cannot be named in the document, and they absolutely cannot have any financial or beneficial interest in the underlying transaction whatsoever.
Because of the fraud risk.
Exactly. Think about it. If an elderly man is signing a deed transferring his house to his nephew, and the nephew is acting as the translator,
The notary has no idea what the nephew's actually saying.
right. The notary has no idea if the nephew is translating, "Do you swear this is true?" as "sign this to get your medicine." The fraud risk is astronomical.
That's terrifying.
It is. That is why in the vast majority of states, if you cannot speak the same language as the signer, you must politely decline the notarization entirely and refer them to a bilingual notary who speaks their native language.
Okay, I want to pose a scenario that I know for a fact is running through the minds of a lot of our entry-level listeners right now.
Okay, let's hear it.
We are talking about these incredibly strict, rigid rules. But let's bring it back to the real world. Let's say a regular customer walks into my mobile office.
Right.
They are stressed, they are on their lunch break, they're in a huge hurry, they hand me a document. I look at the title, and in big, bold letters at the very top, it says, Durable Power of Attorney.
Okay, common document.
Very common.
Yeah.
But I look at the bottom of the last page, and there is absolutely no notary certificate attached.
Yeah.
There is no jurat wording swearing to the truth,
Yeah.
and there is no acknowledgement wording verifying free will. Just a blank line that says signature.
The blank document dilemma.
Exactly. Now, we just spent the last 10 minutes discussing that powers of attorney almost universally use an acknowledgement.
They usually do, yes.
So to save my stressed customer precious time and to provide what feels like 5-star customer service, why can't I just look at them and say, hey, this is a power of attorney. You definitely need an acknowledgement. Print out an acknowledgement form, staple it to the back, and send them on their merry way.
That specific scenario is the ultimate alluring trap for a novice notary.
It feels so innocent, though.
It feels so innocent. It feels like you are just being a helpful professional. It feels like exceptional customer service.
It's not.
But doing exactly what you just described is crossing a massive, highly dangerous legal boundary, and it leads us directly into one of the most perilous areas of our entire profession. The consequences of making that choice for them can destroy the document, and it can destroy your commission.
Wow. Which means it is the perfect time for us to take a quick pause and let that sink in. When we come back, we are going to dive deep into the actual anatomy of these certificates, how to solve this exact no certificate dilemma without breaking the law, and why trying to be overly helpful might actually cost you everything. Stay with us. Commercial break 1. Welcome back to Notary Knowledge. Before the break, we laid down the foundational differences between an acknowledgement, where we are acting as the art authenticator verifying free will, and a jurat, where we are administering a serious legal oath to the absolute truth.
Yes, the two pillars of the job.
But we left off on a major real-world cliffhanger. What on earth do you do when a document is just a blank piece of paper with a signature line and, in your heart of hearts, what certificate usually goes on that type of document? Why can't you just slap it on there?
To truly understand why you can never just make that choice for the client, we first need to dissect the actual anatomy of a notarial certificate.
Okay, let's dissect it.
You need to know exactly what you are looking at and what function each part serves. We casually call this the 4 W's of a notarial certificate.
The 4 W's.
Every single valid certificate, whether it is professionally pre-printed onto the main document by a lawyer or attached separately by you, must contain these 4 mandatory statutory elements to be legally valid.
Let's walk through the mechanics of each one. What's the first W?
The first W is where. This is known legally as your venue.
The venue.
It is usually located at the very top left of the certificate and reads, in standardized formatting, state of blank, county of blank.
Now, novices often get this wrong, don't they?
All the time. This venue does not refer to the state where the document was originally drafted by the law firm.
Right.
And it does not refer to the county where your notary commission is permanently held. It refers exclusively to the exact physical geographic location, the state and county where you and the signer are physically standing right now.
Looking at each other.
Exactly, looking at each other at the exact moment the notarization takes place.
And why is that geographic venue so critical? Like, if I'm commissioned in Texas, I can notarize anywhere in Texas. Why does the specific county matter so much that missing it voids the document?
It comes down to legal jurisdiction and the rules of evidence in a court of law.
Oh, for lawsuits.
Yes. If, 5 years from now, a lawsuit is filed over that specific document, the court needs to know exactly which local jurisdiction's laws govern the signing ceremony.
So if you mess it up,
If you are a mobile notary and you accidentally leave the venue blank, or you write the wrong county because you forgot you crossed a county line during your commute,
which happens a lot,
it does. A defense attorney can argue in court that the notarization is fatally flawed, casting doubt on the entire transaction. The venue establishes the geographic reality of the act.
that makes total sense. Okay, so that's where the second W is who?
Yes, this is the specific name of the signer whose signature is actively being notarized.
Like John Doe.
Right. Most standard certificates will have a blank space embedded in the paragraph that says something along the lines of, "Before me personally appeared John Doe." You must write their exact name in that space.
It sounds almost insultingly simple.
It does sound simple, but you would be absolutely shocked to learn how many critical documents get outright rejected by county recorders or mortgage lenders every single day simply because the notary was rushing and left the who space completely blank.
Just skipped right over it.
Happens constantly. And leaving it blank is an open invitation to massive fraud.
How so?
If you stamp a document and leave the name blank, a fraudster can take that document home and write a different name in the space,
Oh, wow.
making it look like you officially identified someone who wasn't even in the room.
That is terrifying. Okay, what is the third W?
The third W is when. This is the exact, true present date of the notarial act.
The literal day they appeared before you.
Exactly. You cannot, under any circumstances, backdate a certificate to match a date when a document was allegedly drafted. And you cannot post-date it for a transaction happening tomorrow. It is the chronological anchor of the physical appearance.
People ask for that all the time, though. Can you just date it for yesterday?
They do, and you have to say no. Falsifying this date is a fast track to losing your commission and facing criminal charges because the timeline of complex legal events like a real estate closing or the execution of a will relies entirely on the absolute truth of that date.
Right. The timeline is everything in law, and the final W is what?
Yes. This identifies the specific type of notarial act you are actually performing.
This is where you look for those crucial keywords we talked about in the first segment.
Exactly. If you are reading the pre-printed wording and it says acknowledge before me, you know instantly you're doing an acknowledgement.
So no oath needed.
Right, you don't need to administer an oath. But if the wording says sworn to and subscribed before me, you know you are doing a jurat, and you absolutely must make them raise their right hand.
Okay, so those four W's, where, who, when, what, those are the universal baseline across the country.
The baseline, yes. But as a professional, you have to know your specific state nuances, because they can vary wildly from state to state.
Give me an example of a strict state.
Let's look at the state of Florida. Florida notary law is incredibly strict, often due to a history of massive real estate and mortgage fraud in the 1980s and 90s.
Oh, they had a huge problem with that.
Massive. So they actually require 9 specific separate elements on their certificates. 9. Beyond the basic 4 W's, a Florida notary must explicitly note the specific type of identification relied upon.
You can't just casually write driver's license.
Yeah. You should really specify the state of issuance and the ID number in your private journal and note the ID type clearly on the public certificate. Furthermore, Florida now requires the certificate to explicitly state whether the signer appeared by physical in-person presence or if they appeared via approved audio-video communication technology for a remote notarization.
9 separate elements just to make the certificate valid. That is a lot to keep track of in a busy environment.
Yes, and on top of that, they require the notary's official wet ink signature, the printed or typed name of the notary directly below the signature, and the exact unsmudged placement of the official seal.
If it's smudged, it's void.
If any of those 9 elements are missing or obscured, the notarization is considered fatally flawed by Florida law.
Wow.
Now, contrast that heavy burden with a state like Texas, which has a slightly more streamlined statutory requirement.
What does Texas require?
Texas law basically requires the venue, the name of the principal signer, the date, the type of act, the notary signature, and the seal. It is a bit less verbose than Florida, but the core function of verifying the facts of the ceremony remains identical.
So keeping all of that complex anatomy in mind, let's go back to my pre-break scenario.
The stressed customer with the blank document.
Yes. The stressed customer brings me a power of attorney. The document has absolutely no certificate wording at all. No venue, no dateline, no keywords. Just a paragraph of text and a signature line. What is the fundamental dilemma here? Why is it illegal for me to just attach an acknowledgement, since I know that's what a power of attorney usually requires?
The core dilemma goes back to your role as a ministerial official.
Okay, the procedural servant.
Right. Choosing the certificate fundamentally changes the legal effect of the document.
Oh.
If you, the notary, choose to attach a jurat, you are actively deciding to put that person under a sworn legal oath.
Making them liable for the crime of perjury if the document contains a lie.
Exactly. If you choose an acknowledgement, you are actively deciding they are not under oath. Because you are a ministerial official and not a licensed attorney or a judge, you have absolutely zero legal statutory authority to determine the legal effect of a document for another citizen.
Even if I have been a notary for 20 years.
Even then.
And I have personally notarized 500 powers of attorney and 499 of them used in acknowledgement. I can't just play the odds.
Even then, you cannot play the odds. You cannot look at the client and say, most POAs use an acknowledgement, because you simply do not know, and you are not qualified to determine if this specific signer's highly unique personal legal situation is the one rare exception to the general rule.
Because maybe their specific receiving agency demanded a jurat for a highly specific reason.
Exactly. If you choose for them, you are applying abstract legal concepts to their specific real-world situation. That crosses the line from procedural servant to legal advisor.
And that is the unauthorized practice of law.
That is the unauthorized practice of law.
Okay, so if I absolutely cannot choose, and the document is sitting there blank on my desk, what is the exact step-by-step correct protocol to follow so I don't leave my customer hanging, but I also protect my commission?
It is a simple, highly effective 3-step process that you should memorize.
Okay, step 1.
Step 1. Describe the different acts to the signer in plain, accessible English. You tell them, an acknowledgement simply means you are confirming to me that you sign this willingly. A jurat means I must put you under a legal oath that the contents of the document are factually true.
Keep it simple. Step 2.
Step 2, you physically show them sample certificate forms so they can read the actual statutory language for themselves.
Okay, and step 3.
Step 3, you step back and let them choose which one they need.
And what if I do all that and they just stare at me blankly, throw their hands up and say,
Yeah, no,
I have absolutely no idea what any of that means. You're the expert here. I'm paying you. Just pick whatever works so I can leave.
Then you must firmly hit the brakes. You tell them politely, but with absolute firmness, that state law explicitly forbids you from choosing for them.
You just have to say no.
You do. If they truly don't know, they must stop the notarization process right there. They must contact the agency that issued the document, the agency that will ultimately receive the document, or a private attorney to get explicit, authoritative instructions on which certificate is required. You cannot proceed an inch farther until they make the choice.
Right, let's say they step outside, they make the phone call to their lawyer, and they come back in and say, okay, my lawyer says I definitely need a jurat.
Great, they made the choice.
But the document is still just a piece of paper with no jurat wording printed on it. How do we actually physically attach a jurat to this piece of paper?
This is where we utilize what the industry calls a loose certificate, which is also known in some jurisdictions as a certificate form.
A loose certificate is exactly what it sounds like, right? It is a separate standalone piece of paper that contains the pre-printed, legally compliant notarial wording, those 4 W's we discussed, for a specific act, like an acknowledgement or a jurat.
Exactly. A prepared notary keeps a thick stack of these blank forms in their briefcase or their desk drawer at all times.
So when they say they want a jurat,
When the signer makes their choice, say, the jurat, you pull out the corresponding loose jurat certificate, you fill out all the 4 W's completely, you sign it, you stamp it with your official seal, and then you must physically attach it to the signer's main document.
What's the best way to attach it?
The absolute best practice for attachment is to staple it securely to the left margin, directly behind the main signature page of the document.
Never paper clips, right?
Never.
Never binder clips. Never a piece of Scotch tape.
Never. It must be as permanently affixed as possible. And here is a critical zero-tolerance rule. Never, ever just hand a signer a loose, unattached, completed certificate and say, here you go, just staple this to your document when you get home.
Oh, that is a massive, terrifying fraud risk.
The biggest.
Because if you hand a stranger a loose piece of paper with your official state seal and your verified signature on it, they could take that home and staple it to literally anything.
Anything at all.
They could staple it to a completely fraudulent, forged deed transferring ownership of a multi-million-dollar property, and to the county clerk, it would look exactly like you officially witnessed and authorized it.
Precisely. You would be handing them a blank check of legal authority.
Scary.
Which brings us to the ultimate fraud prevention tip when using loose certificates. Most well-designed, professionally printed loose certificates have an optional space, usually at the very bottom of the page, for you to specifically describe the attached document.
I always see that space.
Yes. Even though it is optional in many states, you should always, without fail, fill this out.
What do you write?
You write something highly specific, like, this certificate is attached to a durable power of attorney dated August 2nd, 2026, consisting of 3 total pages, signed by John Doe.
That is a brilliant mechanical safeguard, because if a criminal takes out the staple, separates your certificate, and tries to staple it to a fake last will and testament, any clerk or judge looking at the certificate will immediately see your notes at the bottom.
Right. They'll see it explicitly stating it belongs to a 3-page power of attorney, not a will.
Well,
It completely, instantly neutralizes the fraudulent attempt. It is a simple 10-second habit that heavily protects your commission and protects the public from devastating scams.
10 seconds to save your career.
Truly. But all this nuanced discussion about not choosing certificates and preventing fraud leads us naturally into the broader and frankly much more dangerous territory that every single novice must intimately understand.
Yes.
The danger zone. We have danced around the edges of it for the past 20 minutes, but it's time to face it head on. This is where good intentions pave the road to lawsuits. We are diving deep into the unauthorized practice of law, commonly known as UPL.
Defining UPL for notaries is mostly an exercise in defining exactly what we are strictly legally forbidden from doing.
We already firmly established the first rule. You cannot choose the notarial certificate. But UPL goes much, much further than that. You cannot choose which specific legal document a customer might need for their life transaction. You cannot draft, edit, or prepare legal documents for them.
And the hardest one.
The most difficult one to adhere to in a customer service setting. You absolutely cannot explain the legal consequences of a document to a signer.
That last one is incredibly tough.
It is.
Imagine a signer is sitting across from you. They are finalizing a divorce, and they ask you, hey, if I sign this quitclaim deed today, does my ex-wife still have a legal claim to the equity in the house?
Oh, that happens all the time.
Right, and you have to bite your tongue. Even if you think you know the absolute correct answer, even if you happen to be a licensed real estate agent in your day job,
Exactly.
while you are sitting in the chair acting as a commissioned notary, you cannot answer that question.
The very moment you apply abstract legal concepts to a signer's specific personal situation, you are actively practicing law. To use an analogy, imagine you are a lifeguard who is highly trained and certified in CPR.
Okay.
You are trained for one very specific, crucial emergency procedure. But just because you know CPR does not mean you are qualified to walk into an operating room and make decisions during open heart surgery.
Right.
As a notary, you are the CPR lifeguard of the legal system. If you try to do the open heart surgery of giving legal advice, the patient is going to die and you are going to jail.
That's a vivid image.
It's true. Unless you have passed the grueling bar exam and hold an active license to practice law in that specific state, you are committing UPL.
This brings up a massive systemic issue, particularly in diverse and immigrant communities, regarding the deceptive use of the term notario publico.
This is a massive point of cultural and legal confusion that leads to utterly devastating scams.
Let's explain the difference.
In many Latin American countries, which operate under a civil law system rather than a common law system, a notario or notario publico is actually a highly trained, elite legal professional.
So they aren't just stamping papers.
No, they are akin to a specialized attorney or a high-level magistrate. In those countries, a notario has the immense power to draft complex legal documents, give binding legal advice, and manage intricate legal affairs.
But in the United States, as we have thoroughly established, a notary public is merely a ministerial official, a procedural servant.
Yes.
The roles share a similar name, but the actual power and training are completely, fundamentally different.
And unfortunately, predatory criminal individuals exploit this linguistic translation to steal from the vulnerable.
How do they do it?
They set up storefronts in immigrant communities and advertise themselves boldly as a notario publico. They intentionally imply to recent immigrants that they possess the same vast legal power as a Latin American notary.
It's a total scam.
It is. They charge exorbitant thousands of dollars fees to give legal or immigration advice, which they are wildly unqualified to give.
And the results are tragic.
This often results in the victim's immigration paperwork being filed incorrectly, ruining their chances of citizenship, causing them to be deported, and stealing their life savings in the process.
It is despicable, and state legislatures take this predatory behavior incredibly seriously, don't they?
They do. They aggressively combat these notario scams through targeted, heavy-handed legislation.
Let's look at Texas again as an example.
Perfect example. Texas law requires that if a notary chooses to advertise their services in a foreign language, they must prominently include a very strict, legally mandated disclaimer in both English and the foreign language.
What does it say?
The disclaimer must explicitly state, I am not an attorney licensed to practice law in Texas and may not give legal advice or accept fees for legal advice.
And they can't even use the word right.
Furthermore, Texas completely prohibits using a foreign language translation of the word notary or notary public, specifically the word notario, in any written or electronic material in a way that implies you are an attorney.
Ohio is even stricter.
The state of Ohio takes it a step further into absolute prohibition. Ohio law explicitly and strictly prohibits the use of the term notario or notario publico in advertising, full stop.
So no disclaimers save you there.
It does not matter if you use a disclaimer. Whether it is on a billboard, a pamphlet, or a radio ad, if you use the word, you are directly violating state law and risk severe penalties.
So knowing all this dark reality, how do we navigate these tricky waters on a day-to-day basis? I want to push back on behalf of our listeners again.
Please do.
Let's say a signer comes to my office. They are elderly, perhaps they have limited reading comprehension, or maybe they just don't speak English as their first language.
Very common scenario.
They hand me a complex, confusing legal document that a hospital or a bank told them they had to sign. They are visibly stressed, they're confused, and they're practically begging for my help to understand what box to check or what certificate to use so they can just get it over with.
Right.
Honestly, looking them in the eye and refusing to help them understand their own document feels terrible. It feels cold, bureaucratic, and like incredibly bad customer service.
I completely understand the deeply human empathy. We are in a service-oriented profession, and our natural instinct as decent people is to help those who are in distress. But you have to radically reframe how you think about this situation.
Reframing it how?
Refusing to perform an improper notarization or refusing to give legal advice you aren't qualified to give is not bad customer service. In fact, it is the absolute highest form of protection you can possibly offer them.
How so? How is saying no protecting them?
Think about the disastrous chain of consequences if you say yes. If you, a well-meaning non-attorney, give them slightly incorrect advice on how to fill out a complex property deed, or you guess and choose the wrong certificate for their federal immigration paperwork, what happens?
It gets rejected.
3 months later, their document gets rejected by the county clerk or the federal government. Their property transfer fails, and they lose the sale. Their immigration status is jeopardized, and they face a hearing. By refusing to guess, you are forcing them to pause, step back, and get correct, qualified legal advice from someone who actually knows the law.
You are protecting their long-term legal rights by sacrificing short-term convenience.
Exactly. And crucially, it protects the notary, too, because if you guess wrong, the liability doesn't just vanish.
Absolutely not. If your unauthorized, well-meaning advice causes them quantifiable financial harm, they can and will sue you to recoup their losses.
They absolutely will.
And this brings us to a massive misconception novices have about the surety bond. Before you were commissioned, you likely had to purchase a state-mandated surety bond, maybe a $5,000 bond in states like Arizona, or a $10,000 bond in Texas.
Yes, almost everyone gets one.
Novices often think this bond is like their personal car insurance. They think, if I mess up and commit UPL, My bond will cover it. That is completely false. A surety bond does not protect you. It is a line of credit designed solely to protect the public from you.
Wait, break that down for them. How does the financial mechanism of that actually work if a notary gets sued?
Let's say you commit UPL. A client loses $10,000 and a claim is successfully made against your bond. The surety bonding company will immediately pay the victim the $10,000 to make them whole. But the story doesn't end there.
It never ends there.
The surety company will then turn around and aggressively come after you, the notary, to collect that $10,000. They will come after your personal bank accounts, your wages, and your assets.
It's financial ruin.
On top of that financial ruin, you will likely lose your commission, face civil liability from other parties, and in some jurisdictions, face criminal prosecution for practicing law without a license. Saying no when necessary is the ultimate professional safeguard for everyone involved.
That is a deeply sobering reality, but an absolutely necessary one to hear. We have to draw that hard, unyielding line no matter how much we want to help.
We do. We are going to take our final quick break right here. When we return, we are going to dive into what is arguably the most chaotic, frustrating, and misunderstood act in our entire playbook, copy certification. And then we're going to put you in a hot seat with our rapid-fire scenario segment. Don't go anywhere. Commercial break, too. Welcome back to the final segments of today's deep exploration into decoding documents. We are moving into an area that causes more confusion, more rejected documents, and more heated arguments at the notary desk than almost anything else we do.
It really does.
We are talking about the absolute chaos of copy certification.
Chaos is truly the only accurate word for it. Let's start by laying down a clean textbook definition so we all know what the act actually is.
Good idea. What is it?
Copy certification is a specific notarial act where the notary formally certifies that a photocopy they are looking at is a true, exact, and complete reproduction of an original document.
So it's just proving a copy is real.
Right. The process involves the notary taking the original document from the client, personally making the photocopy themselves on a machine, or closely, hawkishly supervising the copy being made, meticulously comparing the two pages side by side to ensure they are perfectly identical, and then attaching a specific certificate that legally attests to that exactness.
When you describe it like that, it sounds incredibly straightforward. Make a copy, look at it, say it's a good copy, boom, done.
If only it were that easy.
But the reason we call it utter chaos is because of the fragmented jurisdictional patchwork of laws across the United States. The rules governing this seemingly simple act change completely depending on which side of an invisible state line you happen to be standing on.
It's wild.
It is the prime example of why you must know your specific state laws inside and out, and why you must never, ever rely on what notaries in a random Facebook group from a different state are doing.
Exactly. Let's look at the wild extremes of this patchwork. First, we have the states with absolute zero tolerance bans.
States that just say no to everything.
Right. If you are commissioned in Michigan, New York, Ohio, New Jersey, or Illinois, you cannot certify a copy of any document. Full stop. No exceptions.
So it doesn't matter what the document is.
It does not matter what the document is, a utility bill, a lease, a passport. You simply do not have the statutory authority granted by the state to perform that act. If a client begs you, you must decline.
Then you have states with severe, highly specific restrictions that feel almost arbitrary if you don't know the history. For example, California.
California is a great example.
In California, a notary can only certify copies of two highly specific things: powers of attorney, or, if explicitly demanded by the Secretary of State or a judge, entries from the notary's own official journal. That's it. Nothing else.
And Hawaii is even stricter. They only allow copy certification for the notary's own journal entries.
And then look at the complex logic of Texas. Texas has a very broad but incredibly dangerous rule that trips up novices constantly.
What's the Texas rule?
Texas notaries are prohibited from certifying a copy of anything that is recordable with a government entity.
Recordable?
The logic here is about bureaucratic control and revenue. If a document like a deed or a court decree can be officially filed with a county clerk or a state agency, a Texas notary cannot certify a copy of it.
Because the clerk's office is the legal custodian of those records.
Exactly. And they are the only entity authorized to issue official certified copies, usually for a fee that funds their office.
Which brings us to the most common high-risk trap regarding copies, the vital records rule. This applies universally, even in states that generally have very friendly, broad copy certification laws, like Florida and Pennsylvania.
Yes. In states like Florida and Pennsylvania, You can generally certify copies of personal private documents like a residential lease agreement, a high school diploma, or a private business contract.
But not vital records.
You are strictly, federally, and statewide forbidden from certifying copies of vital public records, specifically birth certificates, death certificates, and marriage certificates.
I get pushback on this from clients all the time. People ask for certified copies of their birth certificates constantly because they need them for international travel, enrolling their kids in school, or getting a new job.
Yeah, they hold it right in front of you.
They hold the piece of paper in their hand. They say, here's my original birth certificate, just copy it. Why can't we do it?
Because the premise of their request is factually flawed. The piece of paper the citizen holds in their hand is not actually the true original document.
Oh, that's a key distinction.
The true original vital record is the data securely held in the public custody of the issuing government agency, like the State Department of Health or the Bureau of Vital Statistics.
Right.
The piece of paper the citizen has is already a certified copy issued by that agency. Only that issuing agency has the legal authority and the specialized equipment to generate a valid certified copy.
Because of the security features.
Yes. They use raised seals, intaglio printing, thermochromic ink, and specialized security paper to prevent identity theft. If a notary takes that birth certificate, slaps it on a standard office laser printer, prints it on cheap copy paper, and adds their official notary seal, they are creating a massive loophole.
A dangerous one.
A foreign entity or a less rigorous institution might accept that plain paper as legitimate simply because it has a real notary seal on it. This inadvertently allows human traffickers, counterfeiters, and identity thieves to create whole new, legally recognized personas.
That is the devastating mechanism of fraud you are preventing by saying no.
The stakes are so much higher than just a piece of paper. And speaking of high stakes and counterfeiting rings, we have to talk about federal restrictions, because this is where a well-meaning mistake goes from a state-level administrative fine to a literal federal crime.
This is critical for every notary to memorize. There is a strict, unyielding federal prohibition against photocopying certain federal immigration documents, most notably the Certificate of Naturalization or the Certificate of Citizenship.
You just can't touch them.
Federal law strictly prohibits making unauthorized copies of these specific documents for any reason. It does not matter if your specific state generally allows broad copy certification. Federal law always overrides state law in this arena.
And the penalties are huge.
Photocopying these documents carries severe federal criminal penalties. If a client brings you a certificate of naturalization and asks for a certified copy for a job application, you must firmly decline, step away from the copier, and advise them to contact the U.S. Citizenship and Immigration Services directly for an official duplicate.
But what about standard everyday ID copies? Passports and driver's licenses? This seems to be a massive gray area for many novices because they see it requested so often.
It is a gray area precisely because it is highly dependent on your specific state's administrative code. For example, the IRS often requires certified copies of foreign passports for applications for an ITN, an individual taxpayer identification number.
So can we do that?
States like Florida generally permit a notary to attest to a photocopy of a passport or a driver's license for this purpose. But, as we noted, if you are in Michigan, it's an absolute ban, so you can't help with the ITN application.
And Texas.
In Texas, you generally can't certify a passport because it's considered a recordable document by the federal government. Furthermore, some states specifically ban photocopying driver's licenses entirely due to massive consumer privacy concerns and the rise of synthetic identity fraud.
So the lesson is check your handbook.
You absolutely have to consult your state's specific administrative code or handbook before ever saying yes to an ID copy.
This labyrinth of rules is exactly why the role of a ministerial official requires constant, vigilant study. The rules are rigid, but they're incredibly varied depending on where your feet are planted.
Very true.
Speaking of actively applying these complex rules, it is time for one of our favorite, most illuminating interactive segments. Good question. What would you do?
This is the part of the show where we run through rapid-fire, highly detailed, real-world scenarios based on actual listener locations and dilemmas.
Yes, grab a pen if you're listening.
We want you, the novice listening at home or in your car, to pause for a second after each scenario is presented and try to determine the exact correct procedural answer before we break it down for you.
Let's dive right into the deep end. Scenario 1. David from Ohio.
Okay, David in Ohio.
David is sitting in his busy office, and a desperate client comes in needing a time-sensitive real estate deed notarized today. But the client was just in a horrible car accident yesterday.
Oh, no.
His dominant arm is wrapped in a heavy plaster cast, and he physically cannot hold a pen to sign his name. He has his ID, he has free will, but he lacks the physical ability to sign. What would you do?
If you are David in Ohio, you absolutely do not send the client away. You utilize a specific legally recognized procedure called signature by mark.
Signature by mark. How does that work?
Because the client cannot write their full name, they are legally permitted to make a mark, like a simple X, a line, or even a scribble on the signature line, even if they have to hold the pen awkwardly in their non-dominant hand or in their mouth.
Okay, but how do we prove it was them?
To execute this legally, David must have 2 completely disinterested witnesses present in the room during the signing. These witnesses cannot be David, and they cannot be anyone receiving property in the deed.
Disinterested is key again.
Right. Once the client makes their X, David, the notary, must physically print the signer's first name at the beginning of the mark, print the last name at the end of the mark, and clearly write the words his mark or her mark directly below the symbol.
That's a great safeguard.
This stringent protocol provides a legally verifiable, fraud-resistant way for physically impaired individuals to execute critical documents.
Perfect application of the mechanics.
Yeah.
Let's move south. Scenario 2. Jessica from Florida.
Okay, Florida rules.
Jessica is called out as a mobile notary to an assisted living facility. An elderly woman's family has asked Jessica to notarize the woman's living will. The family is hovering tightly around the bed, visibly agitated, eager to get it done quickly. What would you do?
There are 2 massive overlapping layers here for Jessica to navigate. First, the legal mechanics. Under Florida law, a living will explicitly requires 2 subscribing witnesses to be valid, but it actually doesn't strictly statutorily require notarization.
Oh, interesting.
However, if the family or the customer insists on having it notarized for extra security and peace of mind, Jessica can provide an acknowledgement, provided she adds the proper 4W certificate.
But what is the second, much more critical layer that Jessica has to deal with in that room?
The human element, the core duty of the notary. Jessica must actively assess the elderly woman's basic mental capacity and free will.
With the family hovering.
No, to do this properly, she must politely but firmly clear the hovering, pressuring family from the immediate space.
That can be awkward.
It can be, but it's required. Once alone with the signer, Jessica isn't acting as a doctor diagnosing dementia, but she must ask a few basic, orienting questions. Do you know what this document is? Do you want to sign it today? What day of the week is it?
Just to get a baseline.
She must ensure the woman is alert, oriented, understands the gravity of a living will, and is signing it of her own free will without family coercion. If the woman appears highly confused, disoriented, or heavily medicated to the point of lacking basic awareness, Jessica must refuse the notarization immediately and document the refusal in her journal.
Protecting vulnerable signers from familial coercion is a paramount, non-negotiable duty.
Absolutely essential.
Okay, moving to the East Coast. Scenario 3. Marcus from New Jersey. A client walks into Marcus's office and brings him a foreign passport and a certified birth certificate, both issued by the government of Namibia. The client desperately needs certified copies of these documents to send abroad to an embassy to renew a work visa. What would you do?
If you remember our discussion into the chaos of copy certification just a few minutes ago, you should know the answer instantly. Marcus must politely but firmly decline the request.
Because of New Jersey laws.
New Jersey is one of the states where notaries are entirely statutorily unauthorized to perform copy certifications of any kind whatsoever. It does not matter that the documents are foreign, and it does not matter that the receiving embassy is demanding a notary stamp.
State law wins.
The origin of the document does not override the laws of the state where Marcus is commissioned. Marcus should politely advise the client to visit the nearest Namibian consulate or embassy to obtain official, legally recognized certified copies from the issuing government.
Down to the Lone Star State. Scenario 4. Elena from Texas.
Okay, let's hear it.
Elena is meticulously recording a complex, high-value real estate transaction in her official notary journal. The signer used their current U.S. passport for identification. To be as thorough and bulletproof as possible for her records, Elena starts to write down the exact full passport number in her public record book. What would you do?
Stop. Do not write that specific number down.
Why not?
Texas law explicitly and strictly prohibits notaries from recording identification numbers assigned by a governmental agency. This broadly includes social security numbers, passport numbers, and driver's license numbers in their record books.
Why? That feels counterintuitive. Isn't more detailed information always better for a legal record in case of a dispute?
Not when it comes to the devastating reality of modern privacy and data breaches. A Texas notary's journal is legally considered a public record.
Meaning anyone can see it.
This means that, under certain circumstances, members of the public can legally request to inspect it or get copies of specific line items. Imagine a fraudster legally requesting a copy of your journal line item, and you have written down an elderly person's full name, address, and exact passport number.
Oh, that's bad.
You are literally handing identity thieves a golden ticket on a silver platter. In Texas, you can and should record that a passport was presented and maybe record the expiration date to prove it was valid, but you must never record the actual identifying alphanumeric number. The law prohibits it to sever this exact identity theft pipeline.
Great catch. Finally, heading to the Pacific Northwest. Scenario 5. Kevin from Washington State.
Washington, okay.
Kevin's father comes to him with a quick deed. The father is transferring a piece of family land, originally owned by Kevin's late grandmother, into a new family trust. The father presents his Washington DMV ID to prove his identity and asks Kevin to quickly notarize the signatures to save them all a long, annoying trip to the bank. What would you do?
Kevin must immediately decline the notarization. Washington state law strictly prohibits a notarial officer from performing acts with respect to a record to which the officer or their spouse is a party, or in which they have a direct beneficial interest.
But Kevin isn't actually named on the deed itself, right? It's just his dad transferring the grandmother's land to a trust. Kevin's name isn't on the paper.
The paper doesn't matter, the bloodline and the asset do. The state guidelines clearly outline that it is highly inadvisable and legally perilous to notarize for extended family members.
Because of the conflict of interest.
Because Kevin is a direct legal heir to his father, he has a clear potential future beneficial interest in that family land and that trust. Performing this notarization creates a massive, glaring conflict of interest.
What could happen if he does it?
If a dispute over that land arises in 5 years among siblings, a judge looking at that deed will see that the son notarized the father's signature. The court could very easily void the document entirely based on that conflict of interest, ruining the family's estate planning. Kevin must protect the document by sending his father, along with his Washington DMV ID, to a completely neutral third-party notary.
Those scenarios really highlight how quickly things get complicated in the real world. It is never just a simple stamp on a piece of paper. You have to be thinking 3-4 steps ahead, anticipating fraud, coercion, and liability.
Which brings us to a broader philosophical concept I want to leave everyone with today. We spend a lot of time in this profession talking about wet ink, rubber stamps, paper certificates, and physical presence. But we are rapidly, inevitably hurtling toward 2026's vision of entirely digital, paperless workflows. Remote online notarizations, or RON, are becoming ubiquitous across the country.
Everything is moving to glowing screens, digital certificates, and blockchain verification. It can certainly feel like the traditional human role of the notary is being phased out by advanced technology.
But I assure you that is a complete illusion. Technology changes the medium, but it absolutely does not change the core mission. Whether you are holding a physical paper deed in a hospital room or you are looking at a PDF on a secure, encrypted portal, the fundamental human element remains exactly the same.
The human element.
Your job is still to assess free will. Your job is still to verify identity. Your job is still to look a human being in the eye, whether physically across a mahogany desk or digitally through a high-definition webcam, and determine if they are being secretly coerced.
Because a computer can't do that.
Advanced software can instantly check a driver's license barcode against a massive federal database, but software cannot detect the subtle, terrifying quiver of fear in a domestic abuse victim's voice when they are being forced to sign away their financial independence off camera.
That is a profoundly powerful realization.
The human element is the ultimate, irreplaceable shield against fraud. Technology is merely a tool to facilitate the meeting. The core, sacred duty of the notary to serve as the impartial, ethical, and vigilant guardian of the transaction does not change. As society gets faster, more automated, and more digital, that human pause, that moment of solemn verification that you provide, becomes infinitely more valuable, not less.
What a fantastic, empowering perspective to close on. We covered a massive amount of crucial ground today, from the absolute truth of Jurats to the bewildering chaos of copy certifications. If you have any questions about the complex mechanics we discussed today, or if you have a tricky real-world scenario you want us to break down in a future show, please email your questions to Derek@dereksproul.com. We will try to answer as soon as possible at the end of our shows.
And remember, simply understanding the rules in a textbook is only the first step. You have to have the courage to apply them with confidence in the real world.
Exactly. Before we go, I want to read our credits exactly as requested. Executive producer Derek Spruill, lead writer Marylyn Trotter, graphics Eddie Montes Travis, music Thomas Bynum, produced by Magnificent Works Business Solutions.
Thank you all so much for joining us on this foundational journey today. Stay vigilant out there.
Don't just be listeners of the knowledge, be doers of the knowledge. This is Notary Knowledge. Until next time.
Are you truly protected as a notary public? Navigate the complex legal framework with confidence using Notary Law and Liability by Derek Spruill. This essential guide provides a deep dive into state regulations, ensuring you stay compliant across jurisdictions. Learn how to properly use errors and omissions insurance and master the critical boundaries to strictly avoid the unauthorized practice of law. Protect yourself, your commission, and your business. Get your copy of Notary Law and Liability by Derek Spruill on Amazon.